Hi folks, may cough again. I still got this cold. This is a little out of sync, this video, but I've been asked by a number of people, including the federal government, to prove that someone recognizes us. Well, that's contrary to the Supreme Court decisions. The Constitution will self-identify. We don't need recognition by a colonial. Oh yes, you're native, but I just want to. I have lots of documents to show the government has been recognizing us for a long time. And I'm going to segue for a minute. There was a group in Ontario called the Kawartha Anishinaabe, and they were a group of families, 5 or 7, I forget. They were out hunting and fishing when they did the Williams Treaty, so they were left out of the Curve Lake signature of the Williams Treaty. Okay. Well, I think now they all have their status cards. I could be wrong. You can research it. Some of the chiefs there, leaders, are friends of mine. Anyhow, they went to court on a hunting and fishing violation, or a fishing violation, and when they went to the Superior Court of Justice in Ontario, the final thing, the prosecuting attorney, and I'm just going by memory here, for the province says, well, Your Honor, we don't recognize them as basically a First Nation at that time. Not as a Métis, it was a First Nation. And the judge looked at the stack of papers in front of him, and he flipped through them, Chief and Counsel, Chief and Counsel, Chief and Counsel, Chief and Counsel, Chief and Counsel. And he said, you've been recognizing these people as a native for a long time. And actually, they were actually giving them some funding as well. So they won the court case, and the province had 6 months to a year to appeal it to the Supreme Court, and they never bothered, so they got their hunting and fishing rights, and eventually they got their status cards back, or some of them did. I haven't talked to them for a while. Okay, so in light of that, I'm not to belabor you with all kinds of letters, because this machine gives you a mirror image when I pop it up, but hopefully you can see this. Now this I would expect, because of the legal and governmental history of this organization, that could determine the legitimacy of someone in Canada, right? They would have the knowledge to say, yes, these people are who they say they are, okay? And we've had many correspondence recently, a letter from this most distinguished person to say that they are letting the Canadian government do our constitutional challenge through the treaty process at the UN, and she will allow it to Canada, and she directed the Governor General of Canada to do so. So I don't know if this comes out, because I think it's in mirror image on your screen, if you can read it. That's right from yeah, the Crown, her Royal Majesty. Elizabeth Regina, which is the ER, right to the chiefs of our tribe. So I don't know if that comes out wobbly or whatever. But why I've brought this up is that a number of years ago, when the federal government was going to regulate traditional medicines, I guess they had a big lobbyist push against them, Bill 81, I think it was. They were going to regulate all traditional medicine. So basically, if we went out in the garden, harvested our mint, dried it, put it in a bag and put a label mint and put it in our kitchen, we would have been sued or we would have been charged and got a fine of $280,000. So we put a lot of letters to the then federal health minister, Tony Clement of I don't want to make a comment of his current condition, right? But Tony Clement wrote a letter back to us, to our chief and counsel, saying that no time with the federal government, any time in the future, or never had the intent to prevent our traditional chiefs and medicine people to harvest our traditional foods and medicine and provide them to our people. So essentially that is a federal mandate from a federal cabinet minister that we had hunting and fishing rights in Canada. You know, that will be disputed in courts and they'll argue like crazy, but that's that is there. Whether or not they try to imply it was officially induced error, well, officially induced errors are still a good thing. They've made an error, but they got to live with it. That's contract law. So I was asked by a couple of our community members, and I think there's a letter posted on my community's Facebook or my Facebook. They posted their letter where I said, you know, like, you are who you are and you have the rights to go hunting, and if you have a trouble, I'm paraphrasing because I can't remember what was in the letter, but anyhow, I sent a letter to the Aboriginal group of Ministry of Natural Resources in Ontario, stating that our people, as per our rights to go out into the forests of Ontario this year past, to harvest our traditional foods and medicines, which included, I think I said, deer and moose. I don't know. I don't know if I specifically said. So I got a letter back just not very long ago, I think while in the late end of the hunting season. I've been trying to meet with the Ministry of Natural Resources Aboriginal group for years. They just don't want to meet with us. So they sent us a letter back and said, well, based on Aboriginal harvesting policy, the M&O, or so of the government, they're following the protocols of the Polly case, and that basically the intent of that letter, and I'll try to post them later if I can figure out how to post them later. The Polly case. Oh, hold on for a second. So the Polly case stated that you had to be of a you have to be a Métis, you have to be pre-1885 historic community accepted by the community. So then they get into then that they're recognizing the Polly case, but they're also going under the only people that can hunt is the Métis Nation of Ontario, which is in direct violation of the Polly case because the Métis Nation of Ontario isn't a historic community and they haven't been around until the Polly case was heard. So I will explain more on this later. I just had an elder show up at my door, so I'll explain more on this later, or I'll redo it.